Hello, everyone. My name is Sherrill Corbett. I'm a partner in the business department at Tonkon Torp, and I am today's moderator for this webinar. Welcome to our Labor and Employment COVID-19 webinar. Our hope is to provide you with answers to the most frequently asked questions right now on labor and employment matters. Many of the answers can be nuanced and based on your unique situation. If you have questions unique to your business, we invite you to reach out to our speakers or the Tonkon Torp lawyers you normally work with to discuss your specific situation. Today, we will hear from two panelists answering these frequently asked questions. Blerina Kotori and Creps, both experienced partners in Tonkon's Labor and Employment Department. Blerina and Clay will touch on coronavirus-related employment issues, layoffs, unemployment considerations, paid time off, and more. Please note there is a lot of information and advice, and it will depend on your business's individual situation. Let me pause for a moment and make a note about this webinar format. We are recording this webinar. This webinar format also allows you to ask questions. Feel free to submit them in the Q&A section of your Zoom app. I will do my best to ask a few of the questions as they come up. We want to be sure, though, to have time for the full presentation on all frequently asked questions. So if I don't ask your question right away, please wait for the end. We will conclude with the Q&A session, and we'll try to hit as many of the questions as we can. Another note on this, because the situation is so rapidly changing, we may not know the answer right now, but we welcome you to reach out to us individually after this webinar. You can find our contact information on the links you received with the invitation or on the slides on your screen. And finally, we welcome any feedback you may have after this webinar. If there are topics you want to hear about more, please tell us. We hope to be a source of information for our business community throughout this challenging time and plan to hold additional webinars going forward. So with that, let's get to the program. Let me turn it over to Blerina and Clay, and we'll start with our 7 most frequently asked questions. Question 1. We're all making efforts to comply with the social distancing and Governor Brown's order. Do you have any guidance for employers as they grapple with ensuring social distancing compliance?
Thank you, Sherrill. This is Clay. I first want to say I hope all of you listening are well and safe, and that those you care about are likewise well and safe. Before I answer the question, I want to say a word about acronyms. It was brought to my attention that Blerina and I tend to use acronyms quite a bit when talking about these topics. We're going to try to avoid that, but it is likely you will hear us use them. If you hear us say EPSL, that means Emergency Paid Sick Leave under the Families First Act. That's the first 2 weeks of pay. You may also hear us say FMLA Plus. That means the 12 weeks of FMLA leave to care for a son or daughter because the school or daycare is closed. Okay, now to your question, Sherrill, and that is about guidance with complying with this. Let's start with the basics. Governor Brown's order requires work at home if that is possible. That is, if the tasks that the position requires can be performed while teleworking, an employee is required to do that. If that's not possible, then at the workplace, employees must observe social distancing, which means being at least 6 feet apart. The order also requires the employer to appoint someone to essentially be an enforcer, to make sure that this is being complied with. So first, all employers have to observe those mandates. The key here is communication. Let your employees know we're all in this together and we're trying to keep each other safe. That's why we're doing this. Try to tell your employees not to take offense if they're reminded because they've invaded the social distancing barrier. We're all trying to do our part. And let your employees know that the business staying open depends upon them observing these requirements. Blerina is going to talk a little bit about what the consequences might be if a business doesn't observe these requirements. From a practical standpoint, I think it's always beneficial to post signs throughout the workplace reminding employees to observe the social distancing. Blerina, do you have any other suggestions?
Hello, everyone. It's good to be connected with you today. And like Clay said, I too hope you are all well along with your loved ones. I think Clay covered this really well. The only other point I would make is make sure you analyze your job positions with an eye to essentiality. We're noticing that even businesses who are allowed to remain open sometimes think that every single position is essential. That's not necessarily the case. You might still have to evaluate whether you have to make modifications to certain positions. And then the only other recommendation would be to adopt a written policy, if you have not done so already, that documents all of the good work and the safety measures that you're taking, so that if OSHA comes knocking, as we will talk about later, you have that ready to show it to them.
So Blerina, what would the consequences be for an employer not complying?
Right, this is the hard one, right? So we know that the violations are considered to be a Class C misdemeanor. For businesses, that means heavy sanctions. It's $12,759 for a non-willful violation, and up to $126,750 for willful violations. Of course, you can also be closed by the governor until you demonstrate compliance, and that has its own risks, including for employees who cannot work. But the one that is on the front of everybody's minds right now are OSHA compliance and OSHA inspections and violations. As of yesterday, OSHA had over 2,000 complaints over working conditions due to COVID-19. And the main complaint is that employers are not doing enough to ensure the physical 6 feet distance, or that they're doing jobs that are inherently unsafe. Another thing about OSHA that's unique to this situation is they have reactivated their surprise inspections. That's when they just pop up into your workplace and say, here we are, let us inspect it. It's unclear what process OSHA is using to determine whether they should do a surprise inspection. We understand they've done about 75 maybe to date, but we think that there are various factors like number of complaints, seriousness, the employer's own history with OSHA, imminence of threat. But outside of situations where they just show up, unofficially, we understand that OSHA is generally giving the employers a 10-day notice for the employer to do the investigation and respond to OSHA. Then OSHA is going to use those responses to call out which of them they will pursue and which of them they will let go. So it's very important to submit that response on time and done right. If it's your first response, you know, it's worth spending 10 minutes talking to one of your employment counsels or call us, just to make sure that that first impression with OSHA, particularly in these times, is spot on.
So before we go to the next question, we have a couple of questions from our attendees on social distancing requirements. One asks if positions that are essential are the only ones that can be on site.
Sherrill, I'll take that. This is Clay. The issue with respect to whether the employee should be at the workplace comes down to whether the work can be performed at the work, whether it can be performed by telework. If it can be performed by telework, then it has to be performed by telework. There isn't a necessity that the work be essential necessarily, but if it's not essential, then good common sense just says, don't have that person be in the workplace.
So another question is regarding the definition of social distancing. And I know we've heard that 6 feet is the common standard, but what about walking by each other in the office space? How do you recommend handling that?
Sure, this is Blerina. That is one of the most difficult ones, and that's why OSHA is getting the most complaints about it. Again, unofficially, we understand that OSHA is going to look at the totality of circumstances of the efforts the employers are making, particularly now as there is some studies that show even 6 feet may not be sufficient. What we would say at this time is try to do it as much as possible by putting markings on the floor, perhaps physical barriers. You know, we don't know, but we also don't believe that OSHA will shut a place down just because it occasionally happens. However, consistent violations of that are likely to be more problematic.
Thank you, Blerina. So let's move on to question number 2. How does an employer handle employee confidentiality in these times?
Sherrill, that's a great question. You know, as we are dealing with this, it is easy to think simply about the crisis that we're in and trying to resolve issues related to the crisis. And we may tend to forget the ongoing obligations that businesses have with respect to employee confidentiality. And what we're talking about with respect to confidentiality, of course, is essentially health and medical information that is received from employees. First, we know there are obligations to maintain that confidentially under the ADA and FEMLA. The information must be kept separately, and only those with a specific need to know should be informed. What we're getting in terms of questions here is that this becomes an issue if there is a report that someone has contracted COVID-19 or is symptomatic. And we're getting questions from employers that other employees want to know who that is. Well, that is specifically the kind of information that is protected. So what we are recommending is advising employees that you have information that someone in the workplace has either tested positive or is exhibiting symptoms or was exposed or whatever it is. And you find out from that employee, the one that you have the information about, who they were around. So you first go to those people and tell them that there is information that they may have been exposed. Then generally advise the workplace about a potential exposure without identifying the specific employee. It's fine to identify what department that may have occurred in, what physical location within the workplace that may have occurred in, but you absolutely need to resist all attempts to get specific information about who that employee or employees were. Blerina, any ideas there?
No, I agree, Clay. I think that was a good summary of the issues.
So we have a follow-up question from one of the attendees on the subject of confidentiality. What if an employee is forthcoming and very open and doesn't care who knows? Should the employer encourage them to keep their information confidential? What's the employer's obligation there?
If an employee chooses to disclose any medical information, an employee is perfectly free to do that. In the non-COVID world, we would see this frequently. Let's say someone has been diagnosed with cancer, and they share that with people at the office. And often the purpose of sharing that is to allow others to support that employee. There's absolutely nothing wrong with that. And an employer does not need to encourage the employees not to do that. What needs to happen is the employer, number one, can't share the information itself, and number two, should not in any way put pressure on an employee to disclose that information as well.
Thank you, Clay. So let's move on to question number 3. Unfortunately, right now, so many businesses are having to make the difficult decision of separating with their employees for reasons related to COVID-19. Can you speak about what those separations are looking like?
Yes, that's definitely been on everybody's mind recently. We are seeing a range of them, but the most common separations have been layoffs, which are either permanent or temporary. And in these situations, there is a complete separation of the employment relationship. The employees are off the books. We've seen furloughs, and they've taken a couple different shapes. Sometimes it's just reduction in hours, and in others is a separation where the employee is removed from the schedule completely. And unlike layoffs, furloughs maintain that employee in the books more often than not. And we've also seen voluntary reductions in force or voluntary layoffs. We've seen this, it's unique here because we're seeing sometimes more employees self-select for layoffs, perhaps due to more enhanced unemployment benefits or due to an incentive provided by the employer or other personal reason, perhaps just safety. In themselves, they're not different than other layoffs or furloughs or voluntary separations we see in the legal world, but unique to this situation is that, you know, everybody's hoping that it's temporary and that businesses are considering how these separations work with the small business loans under the CARES Act. And I know we did a webinar on that last week. It's beyond the scope of this webinar here, but that is informing some of these decisions.
So what are some of the considerations for an employer in handling these separations?
So here's what I'd like to do for this. If you have a pen or paper near you, maybe write down, I'd like to give you this sort of 5 quick steps to make sure that you don't forget or you don't skip. Step 1, make sure you've got the economic case for it and that you've got it documented, okay? Don't skip this step. This might be very important later when the dust settles here. I won't get into the economics part of it, but one thing I want you to keep in mind is that separations are not free necessarily, right? What do I mean by that? I mean that in Oregon, as in most states, an employer has to pay final wages upon separation of employment. The rule we have here is that if your furlough or layoff is expected to be more 35 days or more, then you have to treat it as a termination for final paycheck purposes, meaning that you have to pay final wages by the end of the next business day. If you expect it to be less than 35 days, then you just pay them in the next regularly scheduled payday. So that's one cost of separation. The other one is, do you pay out PTO or vacation or sick time? In Oregon, if your policy or practice or employment agreement says that you will pay it out, you have to pay it out with final wages, and that can be significant, as some employees can have, you know, fairly large banks. If your policy says you do not pay it, then obviously you don't have to pay it, but be careful of vague policies or practices because BOLI will usually resolve them in favor of the employee as commitments to pay. Then another way to raise the cost of separations is check to make sure that you don't have any employment agreements that promise severance or any severance policies, because that's another way that you can hike up the cost. Assuming you've crunched all of these numbers, write this down, go to step 2. What are you going to call this thing? Is it going to be a layoff or a furlough? I will say employment lawyers, we love the cleanness and the simplicity of a layoff because it separates the employment relationship completely. But there may be reasons to prefer a furlough sometimes. One of them, for example, is if you're planning to continue healthcare benefits and have talked to your health insurance provider, and they tell you that you have to style this separation as a furlough in order to allow healthcare benefits to continue. So make sure that you partner with that health insurance provider in this decision and ask them if there is any considerations for you at that point. So once you've decided the name, then you want to look at your timeline, okay? A lot of our businesses and clients are having to move so fast in these times. But even with these strange and fast times, there's still at least 3 timelines to keep in mind, okay? 1, Are you going to be applying for a small business loan, and will you care for its forgiveness? If you want total forgiveness, layoffs have to happen before April 26th, which is right around the corner, and the employee or the positions have to be refilled by June 30th. Later layoffs are not impossible, they just reduce the loan forgiveness gradually or proportionally. The second timeline is if you are subject to WARN Act. Only some employers are subject to WARN Act, and only some separations are subject to it. We won't delve into that here unless we get specific questions. We might do another webinar if there is demand. But the main rule is that under WARN, even if you cannot give 60 days notice, you still have to give as much notice as possible, even under unforeseeable circumstances such as this. And then the third one is, will you offer a severance in exchange for a release of claims? If you've talked to lawyers in the past, you'll know that we love to talk about this question, right? Will you offer or get a waiver? If you will, and in your group of individuals who will be laid off, you have employees who are 40 or older, you have to keep in mind the timelines imposed by the Age Discrimination in Employment Act, ADEA. Those timelines briefly are 45 days for these group layoffs, right? For the employees to think to consider if they will sign, and then 7 days for them to change their mind even after they sign. Often you can waive the 45-day, they can choose to waive the 45-day thinking period, but they cannot waive the 7-day. So that's another consideration. Fourth step, who are you going to pick? Who will be in this group? One thing to keep in mind there is that employment discrimination statutes are not suspended during the pandemic. That means that you have to be very careful in your selection process, that you are not inadvertently having more of an impact on certain protected groups. Our usual suspects are individuals 40 or older, individuals with medical conditions who are on reasonable accommodations, or maybe they're on comp leave, and individuals who may have engaged in potentially protected activities like OSHA complaints. So be careful in those, make sure that it's an even spread among the individuals you select. And then the fifth step, how do you communicate it? Compassion goes a long way in every situation, but particularly now we're seeing almost every regulator urge employers for compassion and patience at this time. So make sure you communicate it clearly in writing, phone calls add a human touch, but not at the exclusivity of writing. Don't forget your final wages, don't forget your COBRA, and button it up just as you would any other termination.
So I have a question on any furloughs.
Yeah.
Oh, go ahead. Are you ready for questions?
Sure.
Sure.
How much notice must be given before we institute a furlough? For example, can I give 1 minute notice before a new pay week or period starts? Would that be covered?
Well, the answer to the question is yes. It's not a good practice, but these are difficult times. You know, one can decide to furlough an employee or lay an employee off at any time. Blerina, any other thoughts?
I agree. I think jurists stick to this decision if this was ever challenged. Just because you can doesn't mean you should. So although you can, that's not what we would advise.
Thank you. So moving on to question 4. What are my obligations to my employees under the new Families First Coronavirus Response Act?
Okay, well, there are two very distinct but equally important aspects to the Families First Act. The first is the emergency paid sick leave. And this is a provision for employees who qualify under certain circumstances to receive paid sick leave for 2 weeks, actually 80 hours of paid leave for one of 6 reasons. And I'll briefly go through those reasons. I don't want to get too down into the weeds, but I will get them. The first is that because the employee is subject to a quarantine or isolation order. At first, when this happened, the big question was, does a stay-at-home shelter-in-place order qualify under this? The DOL seemed to go back and forth on that issue, but ultimately said, yes, that does qualify for this. But what's important with respect to this is to qualify for the emergency paid sick leave benefits. The reason the employee is not working has to be because of that order and not because there is no work available. So we get questions like, I don't have enough work for my employees, and so I've sent them home. Are they eligible for emergency paid sick leave? The answer is no. I've reduced their hours. Are they eligible for emergency paid sick leave for the hours that have been reduced? The answer is no, not if it's because there's not sufficient work. So for those reasons, you can't get the emergency paid sick leave. If an individual has specifically been advised by a healthcare provider to self-quarantine or is experiencing symptoms and seeking a medical diagnosis, the individual is eligible for emergency paid sick leave. Now, with these first three reasons we've looked at, the benefits available to an employee cap at $511 a day for a total of $5,110. Now, there are three more reasons that someone can get emergency paid sick leave benefits. If they're caring for someone under one of the first two reasons I gave, the quarantine or isolation order, or the individual has been advised by a healthcare provider, they're caring for someone like that, then they themselves are entitled to benefits. If they're caring for a son or daughter because of a school closure, daycare closure, et cetera, they're entitled to benefits. And if they are experiencing a substantially similar condition, they are eligible for the benefits. The problem is we haven't gotten any guidance whatsoever on what that means. So that one is basically a nullity at this point. If you're an employee who qualifies under one of these last three reasons for the emergency paid sick leave, then you are entitled to benefits that cap at $200 a day for a total of $2,000. Now, a question that arises is, well, I have employees who normally work overtime. I have an employee whose normal work schedule is 50 hours a week. Does that employee get 2 weeks of 50 hours of pay? The answer is no. That employee, all employees are entitled to a maximum of 80 hours. The way the pay would be paid, the way the emergency paid sick leave would be paid out under that circumstance where you have an employee who normally works 80 or 50 hours per week is the first week they would get 50 hours of emergency paid sick leave. The second week they would get 30 hours of emergency paid sick leave. And Blerina, do you want to talk about the second aspect of the Families First Act?
Sure, I'd be happy to. We are calling this, back to our love of acronyms, we're calling this EFML, Emergency Family Medical Leave, and it's still part of the regular FEMLA, FMLA, but what it does is it grants partially paid time off to an employee who is unable to work or telework because they need to take care of their child, either because the school has been closed or because their regular childcare is unavailable due to the COVID-19 or other public health emergency. To be eligible, these employees have to have been on the employer's payroll for 30 days. And pay for EFML works slightly differently. The first 10 days are unpaid, but remember, as Clay said, the employee can use emergency paid sick leave, EPSL, during that time if they so choose. And then thereafter, the employee gets partial pay and that's going to be at 2/3 their regular rate for the number of hours that the employee would otherwise have been scheduled to work. There is a cap to this, just as there is with EPSL, and that cap is $200 per day and $10,000 in total.
So a couple of questions from attendees. Is there any age limit on the son and daughter at home due to school closures? For instance, if I have a teenager at home, does that apply?
This is Clay.
Oh.
If the child is 18 years of age or older, then you can only take this if there is some kind of a disability or developmental disability related reason for needing to care for that child. Yes, if you have a teenager who is school aged, that is someone that you can care for. I'm looking through the guidance right now to see if there's anything else that I should mention. Blerina, any thoughts?
No, I agree with that. And I would also emphasize that the leave is for the employee being unable to work or telework. So even for children who are younger, there is a question of what does it mean to be unable? Is it just a simple distraction because the child is in the background watching TV enough to qualify as unable? We don't think so. Some more guidance on this point would be welcome, but I agree with Clay on the age and on the ability of the child to care for him or herself if they're older than 18.
Another question on EPSL. How do you calculate EPSL for an employee who earns commission as part of their pay?
What the guidance provides with respect to how you calculate this is that you take their average pay over the preceding periods, a 6-month period, and that is what it is based on. But remember, with the EPSL, it is capped for the first 3 reasons at 511, and for the second 3 reasons at 200, and then you have a similar cap for the FEMLA Plus. Blerina, any other thoughts?
I agree with that.
So Clay, do you have any advice on handling intermittent leave or return to work rights?
Absolutely. The rules around intermittent leave are a little bit complicated. They depend on whether the employee is taking a leave for ESPL or EPSL, I'm sorry, or FEMLA Plus, and it depends on whether they're teleworking or working from the actual physical site. When we're talking about paid sick leave, the emergency paid sick leave, if the individual would be working from the usual work site, then essentially intermittent leave is not available if they are taking the EPSL for any of the reasons besides needing to care for a son or daughter whose school or daycare is closed. What that means is it must be taken in full day increments, and that once an employee begins taking it, they must continue until either number 1, they've exhausted it, or number 2, they no longer have the qualifying reason. This makes sense because those first 5 reasons are specifically intended to help prevent the spread of the disease. So we don't want an employee who's qualifying because of one of those reasons to be bopping in and out of the physical workplace. If the EPSL is because of the school or daycare closure and the need to care for a son or daughter, then whether it's EPSL or FEMLA Plus, and the employee is teleworking, then that is available. So if an employee is teleworking, intermittent leave is available. If an employee is working from the workplace, then intermittent leave is only available if the reason they're taking the leave is because of the need to care for the son or daughter whose school or daycare has been closed. Then we get into issues about return to work and what are the rights of employees who have taken this leave, the emergency paid sick leave or the FMLA Plus, to return to work. What are the obligations of employers with respect to those employees? Generally, the requirement is to provide the same or nearly equivalent job to an employee who returns to work following leave. We know that under FMLA, generally, that's the obligation. Clearly, for an employee who takes EPSL, they have the right to return to their job. It's important to note that despite the fact that an employee is taking this leave, the employee is not protected from regular employment actions, such as a layoff for reasons that there simply isn't the work there, which would have affected the employee regardless of whether they're on leave. There are a couple of exceptions which are kind of technical. One is for highly compensated employees, and the other is for employers with fewer than 25 employees about whether they actually have to return that employee to work. If you have a question about that, we should talk offline. It gets a little complicated. Blerina, any thoughts?
No, you got that.
So we have a couple of questions, Blerina and Clay, on the Families First Act related to what size companies does this apply to?
So you want to handle that,
Blerina? Sure, happy to. So the Families First Act applies to employers with 500 employees or less.
Thank you.
Yeah.
So do you have any indication of when employers need to start complying with this act?
Yes, and actually, I would like, there was an earlier question about the age of the child in terms of being able to care for them and being eligible to take their leave. We do have some indication from IRS, so not from the Department of Labor, but from the IRS, that says that if the employer wants to claim the tax credit for the payments of EFML, Emergency Family Medical Leave, the children, there needs to be special circumstances if the child is older than 14. But this is only for purposes of determining tax credit, not whether the employee is entitled to take that time off for leave. So I just wanted to clarify that one point. In terms of your immediate question, Sherrill, which is any indication of when employers have to start complying, the Families First Act became effective on April 1. The Department of Labor has indicated that they will not enforce the act for the first month. However, I want to caution everyone from saying, well, that just means I don't need to worry about it until May. Just because the DOL is not enforcing it, it does not mean that you do not have to comply now that it's effective. So I would advise clients and all employers to use this month, this runway, to firm up their compliance and show their efforts to get ready in the event there's an issue later.
I have another follow-up question from one of the attendees. Can an employer require a doctor's release to work for a person who's been out on a Families First Act for their own COVID-related illness or doctor's quarantine order?
The answer to that is absolutely yes. Under FEMLA generally, an employer is entitled to request a return to work certification that can be requested for an employee taking emergency paid sick leave or FEMLA Plus. Obviously, at this time, it's kind of hard to get into a doctor at times, so that may be problematic. some employers are foregoing a release from a doctor, and they're just getting confirmation from the employee that they have been symptom-free for a sufficient period of time. What that is I've read varying accounts of that. Some say 72 hours, some say 48 hours, some say 7 days. So you don't have to get a doctor's note, but clearly you are entitled to have one if you want.
Moving on to question 5, how does the Families First Coronavirus Response Act affect paid time off, sick leave, and other time off policies?
Yeah, that's a good question. It comes up quite a bit. The short answer is that Families First is a federal law, and it doesn't affect any of the current Oregon laws. And as applicable to this situation, there's 2 Oregon laws that employers still need to comply with. And for employees, their rights under those Oregon laws are in addition to their rights under Families First. The first one is the Oregon Sick Leave Act. This act was passed 4 years ago now, and it basically provides employees with paid time off for a list of reasons related to sickness of themselves or eligible family members, etc. It is unique though, because in this situation, when you have school closures, the Oregon sick leave applies in those situations. BOLI has clarified that the Oregon Sick Leave Act will apply to employees, not just if they get sick or diagnosed, not just if their family members get sick or diagnosed, but also when the schools are closed or childcare is closed because of this pandemic, when the work is closed and the employee is not able to telework. And most uniquely, and this is important, so I want to pause and highlight it, BOLI has stated that sick leave is available to an Oregon employee, even in cases when the employee just simply doesn't feel comfortable coming to work because there's others there sick, that are sick either with COVID-19 or similar symptoms, or simply because the employee has chosen to quarantine themselves. So that's unique, right? That's even broader than Families First. In addition, the Oregon sick leave differs from Families First because it's at the employee's full regular rate for the amount of time that they have accrued or that has been allocated to them, which has to be a minimum of 40 hours, right? Another thing to keep in mind with Oregon sick leave is that most of our Oregon clients and employers are used to being able to request a doctor's note if the absence is more than 3 consecutively scheduled days. Nowadays, though, the CDC and BOLI and others are discouraging employers from requesting or insisting on a doctor's note so as not to overwhelm the healthcare system. Another unique thing about Oregon sick leave that I want to highlight is that it has to be restored if the employee is rehired within 6 months or 180 days. That's particularly important for temporary layoffs or furloughs that we discussed earlier. Make sure that you keep that sick time frozen for them, and even if you paid out on termination. We have gotten indications from BOLI that says you still have to reinstate the balance of unused sick time. You just can give it unpaid at that moment if you have paid it on termination. Then separate from sick leave, we always have our good old OFLA, Oregon Family Leave Act, which has been on the books for a while, and that can be used. It's usually unpaid, but it can be used for school closures, right? For childcare, if the school is closed, and employees have the right to use their available PTO concurrently. Although OFLA leave is not required to be restored like sick leave, there are job restoration rights for OFLA as well. So those laws are both alive and well, and probably will both be very strongly enforced by BOLI.
Blerina, do you want to talk about unlimited PTO?
Can I jump in here, Blerina? I want to talk about, okay, one thing I want to mention is, and I can see the questions are being asked, and I want to clarify something. There's a question that asks, if remote work is available under FEMLA Plus, then an employee does not qualify for FEMLA Plus. Is that accurate? No, that is not accurate. If the employee can work remotely, but the obligations they have to take care of the child who cannot be at school, who cannot be at daycare, interferes with their ability to work, they are entitled to FEMLA Plus for those hours they're not able to work because of that. Just want to say that. Now, one of the issues is how do employers' existing PTO policies and their obligations under FFCRA FFCRA, interact for purposes of how much an employee is going to be paid. And the first question is, can an employee use their own PTO to sort of top off the EPSL? EPSL tops out at $511 for the first 3 reasons and $200 a day for the second 3 reasons. What if an employee normally makes more than that? And with respect to EPSL, an employer can allow employees to use their other PTO, et cetera, to bring the amount that they're receiving with the EPSL up to their normal wages. An employer cannot require an employee to do that, however, for the EPSL. So they can allow an employee to do it, but they can't require an employee to do it. After the first 2 weeks of pay, any pay that an employee is going to get under the Families First Act is going to come because they're on FEMLA Plus. If they are on FEMLA Plus, an employer can require an employee to use their PTO to supplement the 2/3 pay the employee is receiving. If they do that, if an employer does that, then they must ensure that the employee receives the full amount they're entitled to under the PTO policy. After the PTO money is exhausted, the employee would go back to the 2/3 with the cap on it. And Blerina, you want to talk about the unlimited PTO?
Yes, I'm happy to do that. So these unlimited PTO policies, and this actually is specific to Oregon only. So if there are any attendants that are not in Oregon, different rules may apply there. But, you know, a couple years ago or so, the unlimited PTO policies became all the rage, and they're still very popular for retention and recruiting purposes. But they're really raising some unique issues during this pandemic. Because the question is, why would an employee who has the choice of unlimited PTO ever require to use Families First Act or emergency family medical leave? And so employers are really trying to figure out how to deal with these policies. And it's really, we've got 2 solutions. Again, these are new things. We're kind of making them up sort of as we go. One solution is that depending on the language of your unlimited PTO policy, you may be able to temporarily suspend it for the duration of the pandemic. What do I mean by that? Well, check your policy. Does it say things in there like it's at the employer's discretion if there are any changes? Do you have to give advance notice? Can you basically make any changes and just redistribute the policy to your employees? In this situation, provided the language of the policy is correct, you may be able to suspend it temporarily. You can only do so prospectively, right? So not for rights that have already accrued, PTO things that have already been approved, for example. But for prospective changes, you should, with an asterisk, you should. We don't know how this is going to be tested in Oregon, but you should be able to suspend it. And another option, which is not ideal, and it kind of makes everybody's stomach turn a little bit is if you're not able to suspend those policies safely, then your only other option may, if use of unlimited PTO becomes financially really burdensome, the only other option might be a temporary layoff, right? Because you might not be able to keep up with the expense. You have to be very careful if you are doing a layoff for these reasons. I strongly encourage you to reach out to your counsel for that, and how you communicate it to the employees and how you stage it. And you'd want to make sure that you are being clear that employees are not continuing to accrue or use unlimited PTO during that layoff or furlough period.
So before we leave this question, I have a couple of attendees who just wanted to ask clarification. Blerina, you mentioned about the Oregon sick leave, that it could be used by an employee if they don't feel comfortable going to work. Can you state that again? A couple of people want some clarification on what you meant by that.
Yeah, I don't blame them. We ourselves had to read it a few times to believe our own eyes. This was a recent clarification from BOLI. It's on their COVID web page. And really, there isn't much clarification for it other than what we have, which is that according to BOLI, they think that if the employee is uncomfortable to come to work because others are sick, they're showing symptoms, or if there's a diagnosis, I suppose, then they can use their available sick leave. Or if they decide they wish to self-quarantine. Now, BOLI has not clarified exactly what they mean by quarantine, right? We have some guidance from the DOL, as Clay explained, about quarantine and isolation orders. We don't have that similar guidance from BOLI. So we assume that the least risky interpretation of it would be when an employee just simply says, I want to quarantine and shelter in place because of Governor Brown's order. Now, again, this hasn't been tested. This is the guidance we have received. What I would say is that Oregon sick leave, just like any of these other statutes that we are covering in detail, is an employee favorable, an employee-friendly statute, meaning that it is for the benefit of the employee. And the least risky way to apply it would be in favor of granting that sick time for that purpose.
And Blerina, so everyone understands, the amount of time under the Oregon Sick Leave Act that is protected is 5 days, 40 hours. So that is the amount of time that the employee would be able to say, I'm freaking out, I'm scared, I don't want to be in the workplace, I'm going to take that time off. That's 5 days.
Thank you for clarifying that. So we're almost close to our 1 hour mark, so I want to get through the last two frequently asked questions. So we'll move to question 6. How does an employer handle salary and other compensation reductions due to COVID-19 reasons?
Yeah, so this is another common thing that we're seeing right now is employees are really trying to sort of keep as many bodies, keep the family together, and they are choosing, instead of layoffs, well, can we do this by reducing comp for everybody, kind of sharing the burden a little bit. An employer has the right to do that, but I'd like to flag a couple of issues to be aware of. For one, remember those discrimination laws. They're still in full force and effect. So make sure if you're going to do something like that, that it's done equally among similarly situated employees. 2, be very careful about retroactive application, right? If you're going to change compensation like salaries, make sure that it is done prospectively and that employees are that they're very clear in your communications with them. You also want to be very careful if there are any employment agreements in place. I saw this come up a couple times when the employer has a contract that was entered into 7 years ago and they forgot because it's a crazy time. And that contract promises a certain amount of salary. Be careful about changing for those individuals because you might need to amend that agreement temporarily. In addition, there's some unique considerations for exempt employees. Remember that salaries cannot change by quality or quantity of work. So if you're going to reduce salaries for exempt employees, you want to be clear in your communication to the employee to say, look, although your salary has been reduced by X%, our expectation is that you would also reduce that time by the same amount, say 20%. However, if it takes longer for you to get the job done, by all means, you're expected to take all that time that you need to complete it, but your salary is not going to go up or down based on your hours. In other words, it's reduced and it's still fixed. For non-exempt employees, it's a little different, right? It's not really so much as a reduction in pay, but rather a reduction in hours or in the hourly rate. And you just want to make sure that you don't go below minimum wage and that you're very clear in communicating any limitations to overtime, because for non-exempt employees, even if they work overtime without your permission, as an employer, you would usually have to compensate that at their overtime rate. Clay, anything else to add there?
I would just say it's perfectly acceptable to reduce the salary of an exempt employee. Just bear in mind that in order to preserve the exempt status, they still need to make a certain amount per week. So if your reduction in their salary takes them below the federal level for the salary test, then you have destroyed their exempt status and they have become non-exempt employees. So you want to be careful about that. The other thing I want to say, this gets into the unemployment. A reduction when you're working with non-exempt employees, it makes the most sense for them and for you as an employer to do a reduction in hours rather than a reduction in pay or a reduction in the rate of their pay, because they would then be eligible for the unemployment benefits based on that.
Thank you both. So let's move on to our last frequently asked question, question number 7, which is, how involved should I be with my employee's application for unemployment benefits?
Well, this is a situation where the times make for interesting bedfellows. You know, normally employers are not all that involved in the unemployment process, except to respond to the questionnaire provided by the Oregon Employment Department. But in these times, employers are becoming increasingly involved and wanting a lot more information. There are a couple of reasons for this. They want to be able to help their employees. They know this is a tough time and they want to help them, so they want to have the information about what benefits are available in the process. The other reason is that employers are trying to figure out the best way to take care of their employees. Will an employee be better off if I simply furlough the employee, lay them off, reduce their hours, get them on the work share program, make them eligible for the $600 per week of enhanced unemployment that we've gotten through the Federal CARES Act? Or would it be better to allow them to be able to access EPSL or FEMLA Plus? And making that calculation is going to be different for every employer, for every employee, based on what their income is, their wage. But that's where we're seeing the intersection of those things occurring with respect to the applications for unemployment benefits.
So Clay, we have a question here about the work share program. Can an owner who's also an employee of the company get work share?
Anybody who is an employee, if they are a non-exempt employee, is eligible for work share. Exempt employees aren't eligible for the work share program because that is a specific program that says where you reduce somebody 20 to 40%, they can go in there. They do that based on the hours worked. And since exempt employees don't have to track hours, exempt employees are not going to be eligible for work share. I say that because if somebody is an owner and they're also an employee, they are probably considered an exempt employee rather than a non-exempt employee. It is true that an employer at any time can convert an exempt employee to a non-exempt employee. So you could do that as well and then get the owner eligibility to participate in the work share program as well.
And I would also add that,
oh, go ahead.
Oh, sorry. I would add that under the new CARES Act, it's clear that owners should be eligible for that $600 benefit. So they are included under the CARES Act too.
Well, thank you both. I know we've come to the end of our program and we're at our hour mark. Are you two available to answer maybe one or two more questions before we wrap it up?
Sure.
So I'm scrolling through the remaining questions that we haven't gotten to. One of the attendees asks if they're offering intermittent or partial day use of emergency leave at the offering intermittent or partial day use of emergency leave at the employer's option, or must it be granted if requested by the employee?
Give me 1 second. No, it is always at the employer's. Well, here's where we have DOL doing this. We encourage employers and employees to work together here. It is, per the wording of the guidance, at the employer's option, but they're encouraging employers and employees to work together to resolve those issues.
Another question that came up is, can a business change a position from an exempt to non-exempt status and then move the position back to exempt once the COVID crisis is over?
Sorry, I'm happy to take that. I would say this: yes, a business can always change an exempt position into a non-exempt position, subject to some of the points we talked about above. In terms of changing it back, I want to highlight a couple of things. One, be sure that the exempt position was truly exempt to begin with. What do I mean by that? I have seen in the last several weeks many employers use the terminology salaried and exempt interchangeably. The salary component is only one part of determining whether an employee is exempt. The other part is that they have to be performing duties and responsibilities that are unique and that are specific for the exemptions that are recognized under state and federal law. So the reason I say that is this: this might be a good opportunity for employers to examine those positions, you know, in a few months when the dust settles, and see if there's anything that they need to correct there. Assuming that the employee is truly exempt under federal and state law, then nothing should stop the employer from changing that position back into an exempt status. If the position is such that it really isn't exempt under either federal or state law, that would be a good opportunity to try to figure out the best way to handle that transition.
So I think we'll do one more question and then wrap things up. If we reduce all salaries by a specific percentage, let's say 10%, can employees use paid family leave to supplement the salary reduction?
No, go ahead, Blerina.
No, you go for it. I had the last one.
Okay. No, the paid family leave and the EPSL is not for reductions in salaries. It's when an individual is unable to work for one of the enumerated reasons. So simply the fact that they've gotten a reduction in salary is not going to trigger eligibility for either of those benefits.
Thank you for answering all of those, and thank you for all of the information, both of you. So we've come to the end of our program. I know I wasn't able to get to all of your questions, but if you do have questions that are particular to your circumstances, we invite you to reach out to either of our speakers or your Tonkon Torp lawyer that you normally work with. We hope that you found this session valuable and invite you to watch for additional webinars planned in the coming weeks. We do also have a COVID-19 business resource page that can be found at our website at tonkon.com. Thank you all again for joining us, and hope you are well and stay safe.